What are defenses in a murder case? If you're watching this video, you're interested in the topic, or you've recently had a loved one who has been arrested for murder and is pending murder charges, and you're interested in this topic, stick around. I think you're going to like this video. My name is Dod. I've been a criminal defense attorney since 2004. My firm is here in San Diego, California. I practice exclusively criminal defense. I handle murder cases. I've handled several murder cases. I've taken several murder cases to trial. Today, what I want to talk to you about, what are the defenses in a murder case, right? You've been accused of murder. Well, what are the defenses? And really, the defenses in a murder case are, number one, it wasn't you, right? You didn't commit the murder. Number two, it was you, but it was self-defense. It was you, but you acted in defense of others. It was you, but you lacked the intent, or it was an accident, and you could get an involuntary manslaughter. It was you, but you acted under a sudden quarrel or heat of passion. So let's be very clear. The only two defenses in a murder case that are going to allow you to walk out of that courtroom a free man is a not guilty verdict because it wasn't you, or not guilty by reason of self-defense or defense of others. If your attorney is arguing for a lesser second-degree murder, voluntary manslaughter, involuntary manslaughter, other, things that your attorney might argue, imperfect self-defense, other things that your attorney might argue, those aren't going to send you home. You're going to do time, a significant amount of time, depending on what you go down on, but you're not going to walk out the door. So let's talk about the number one defense in a murder case. It wasn't you. Okay? So that is the most common defense in a murder case, is the person who has been accused of a crime didn't commit the crime. They didn't do it. And you're going to trial to show that it wasn't you, and it's up to your attorney to hold the state to their burden and make the state prove you guilty, beyond a reasonable doubt. Now, in this day and age, I'm going to be very honest with you. In this day and age, with all the technology that is at law enforcement's disposal, with all the money that they have, with all the power that they have, with all the cell phone triangulation and cell phone tower records that they have, with all your cell phone records that they have, with all the video surveillance that they have, with everybody constantly being recorded, it is hard to beat murder cases on it wasn't me type of defense. It happens all the time though, but they're hard because there's so much technology out there at the government's disposal to place you allegedly at the scene of a crime. Now, the most common it wasn't me type of defense is a faulty eyewitness identification, right? Where an eyewitness says, oh yeah, that was the person that, committed the crime, and it wasn't you, and there's no other evidence that places you there, and it could be some sort of, cross-racial, identification, and your attorney's going to have to get a expert on, misidentification. So, that's very common. But in this day and age, a "it wasn't me" defense is difficult because there's so much technology out there that can prove or disprove that, in fact, you were there or you were not there. So that's number one. And number two is self-defense, right? You committed the crime. You killed somebody, but you acted in lawful self-defense. Now, here in California, what is lawful self-defense? You had a good faith belief that death or bodily harm was about to occur to you. So you acted reasonably by what you did because of that good faith belief that you were about to be killed or someone was about to inflict significant bodily injury on you. So that's another defense that you can run on a murder case. Another defense that you can do is something called a mental health defense. Not guilty by reason of insanity, right? You can go with not guilty by reason of insanity, but they're very difficult cases to beat. And if you're found not guilty by reason of insanity, then you will be committed to a state mental hospital for an indefinite term, could be the rest of your life. The common misconception that the majority of the public think is that if you're found not guilty by reason of insanity, you go home, and that's false. If you get found not guilty by reason of insanity, you will be committed to a state mental hospital for the rest of your life. But these mental health defenses, those are different topics that we'll talk about on different videos. But for this video, we're just talking about the common defenses in a murder case. Number one, it wasn't me. Number two, it was me, but it's self-defense. And if they find true self-defense, then you go home. Whether it's a not guilty verdict of self-defense, or if they found you not guilty of it wasn't you, then you're walking home and going home that day if the jury finds you not guilty. There's a lesser of self-defense called imperfect self-defense. So if the jury says you had an unreasonable belief, but an honest, good faith belief, then you could go down on a voluntary manslaughter. You're still going to do time. Where majority of cases fall is where your attorney is going to argue for something less than first-degree murder, okay? Because here in California, a first-degree murder conviction is 25 to life. And then there's enhancements, gun enhancements. Could tack on additional 25, could be 50 to life. A second-degree murder is 15 to life. If you used a knife, that's an additional year. If you used a gun, tack on an additional 25, depending on how it's been charged. So a lot of times what your attorney will do in a murder case is try to get a lesser, right? So if you're charged with first-degree murder, can we get it down to second-degree murder, right? So if it's first-degree murder, we're going to try to get it down to second-degree murder. If we can't do that, if we can get it past second, then is it a voluntary manslaughter? Is it an involuntary manslaughter? But anything, whether it's a first, second, voluntary, or involuntary, you're still going to do time on those. It's just an issue of, how much time. So what most attorneys will do is try to get it out of the murder, out of the first, out of the second, and into the manslaughter world. Once you get it into the manslaughter world, then you have hope and you will get out at some point. And we call it a determinate term, meaning, if you go down hypothetically on a voluntary manslaughter with a gun, then you get 21 years. Well, we know it's 21 years and you're going to get out in 21 years. Whereas if you went down on first or second degree murder, it's 25 to life or 50 to life or 15 to life or 20 to life. And you don't know if you're going to get out because you still got to go through the parole board. So murder cases are very difficult. And like I explained to you, the two most common defenses are, it wasn't me, it was self-defense. Everything in between, then you're still going to do time. As long as you get off the murder charges and you get a determinate term, voluntary manslaughter, involuntary manslaughter, you're going to get a determinate prison term and you'll be getting out at some point. I hope you like this video. Hit the like button, hit the notification bell, subscribe to our channel, 619-814-5110 if you have any questions about a murder case. Have a great day.